So again, welcome everybody. My name is Gianna Romani, and I'm a regional director for Castle Group, who I am extremely proud to represent today. Castle Group is a property management company privately owned by Florida residents, and we partner with over 300 associations throughout the state. So we actually specialize in communities with either on-site or dedicated management. So that could be a condo of any size that might have front desk staff, maintenance personnel. It could be an HOA with amenities and a social aspect. So we have lifestyle directors, maybe a chef, food services, fitness attendants on site. It could even be a 1,500 plus unit HOA with no amenities. But because they're so large scale, we need dedicated staff to stay on top of things like covenant enforcement, which we'll be talking about today. And with that, I'm going to turn it over to our expert of the day, Adam.
Thanks, Gianna. I appreciate the opportunity to address everybody here. And of course, I will thank Castle for inviting us to provide this information to everybody that's attending remotely today. As you've seen already this morning, we're still getting used to, or at least I am still getting used to the remote participation that everybody is participating in right now in our current circumstances. So I appreciate you having us here to address these issues. Just before we get started, a couple of things about myself and my law firm. I'm a partner at the law firm of Arias Bossinger. We have 8 attorneys, 4 of which are board certified experts in condominium and planned unit development law. Myself and my 3 other partners, Frank Lacquaniti, Carlos Arias, and Sonia Bossinger, are all board certified, meaning that we're 4 of among less than 200 attorneys statewide that have been verified by the Florida Bar as experts in this area of the law. So we're very proud of that. Our practice is dedicated to community association law. I myself have practiced nothing but this area of the law my entire career. So we are well versed and appreciate the opportunity, frankly, that this terrible tragedy and circumstance has put us in terms of servicing our clients. Because what we're doing, and you'll see this throughout the presentation, is we're falling back on legal tools and tools of the industry to solve a problem that, frankly, none of us have ever experienced before. And in doing that, we need to have flexibility. This is kind of, my colleagues and I are joking, as from a legal standpoint, it's trying to fit a oval cube into a round hole. It's not quite square, it's almost there, but it doesn't fit quite neatly enough. So my editorial comment before we get started is, I think we're probably going to see some legislation in the future that will address some of these issues that associations have been facing, just generally speaking, since the pandemic started. So, but without further ado, let's go ahead and get started with the class. And again, the class is covenant enforcement in a COVID environment. And Gianna and I talked about providing this class simply because even though we're all quarantined and we are practicing social distancing and the future is somewhat uncertain in how business is going to operate, one thing that can be said is that business must continue to operate in some form or fashion. And that is particularly the case for community associations. From a business standpoint, there are a lot of retail businesses that have shut down or that are non-essential services, so to speak. And people are being told to stay home if at all possible. Well, where is home? It's in condominium associations, it's in homeowners associations, and anecdotally, the community association managers that I have spoken to have actually reported an uptick in activity in their managerial side of things, simply because people are in the communities all the time now. And so there are more issues that are popping up. So,
and that's what we're saying here, Adam. It's business as usual in unusual times, right? So, Site inspections are continuing. Property management companies, of course, have been deemed essential services. So our staff have been equipped with designation certificates letting people know if questioned that we are essential and we're out there working.
Yeah, and actually that's a good point to address. Having those certificates, providing those to not only your management staff, but also if you are an association that has actual employees that are directly employed by the association, it is important to have those certificates designating them as essential workers for your essential business. So anyway, the overarching procedure for this class is going to be centered primarily upon the normal circumstances of covenant enforcement. So I'm going to take you through the process of normal covenant enforcement. And within that process and within that explanation, we're going to hit on COVID-specific issues. And as Gianna mentioned as well, please, I encourage you to submit your questions. We had some questions submitted ahead of time, but please submit them. We'll try and get to those at the end. We'll get through this as quickly as possible so we can do some live Q&A at the end of the presentation. So without further ado, so we're going to start from a very basic premise here, the covenant enforcement fundamentals. And I do this because everyone in their mind, or for the most part, will think of covenant enforcement as starting at the demand letter, right? That's the first step that everybody thinks of. You notice a violation, you send the demand letter. And it actually comes a little bit before that from a legal perspective. And the reason being, you actually have to have a specific provision of your governing documents that you reference for there to be a violation. And that seems like a relatively simple concept, and it is, but there can often be assumptions that are made with the turnover that can happen on volunteer boards. Perhaps there are some draft rules and regulations that have been circulated that were never approved. So it's important to, from the beginning, make sure you understand the hierarchy of the governing documents and know that those violation letters are not just a arbitrary, hey, we don't want you to do this on your lot. You actually have to tie it to your governing documents. And so just to make sure everybody is on the same page with this, governing documents have a hierarchy as they're indicated on your screen right now, with the declaration taking the highest priority, then the articles of incorporation, then the bylaws, then the rules and regulations, and then architectural guidelines. And the last two there are kind of can trade places back and forth to some degree, depending on your specific governing documents. But this is generally the hierarchy that you will see. Okay, so substantive issues related to enforceability. So before you move forward with covenant enforcement, you need to evaluate with your professional management and your legal counsel whether or not you have enforceable rules. And generally speaking, most of these things hopefully will be taken care of in the drafting of the restrictions. Primarily, we see covenant enforcement issues coming to the surface from rules and regulations that are adopted by boards of directors. And in that process, presumably you're working with counsel to ensure that these are passed directly. But there are some hurdles from a substantive standpoint, and I'll get to the next side being procedural, that you need to keep in mind. So for a recorded declaration, this is your covenants and restrictions if you're an HOA, and this is a declaration of condominium if you're a condominium association. They are presumed to be valid if they're recorded, unless they are wholly arbitrary, against public policy, unconstitutional, or constitute a change of scheme for homeowners associations. And the reason that's important to understand is that it is completely different from the reasonableness standard that would apply to rules and regulations as well as architectural guidelines. So the reasonableness standard for rules and regulations and architectural guidelines is a much more factually specific analysis of whether or not it is reasonable for your association to prohibit dogs that are over 100 pounds. And let's use a factually specific example there for that, that overweight dog restriction. If you're in a high-rise condominium with units that are right next to each other, where people are going to be having to share stairwells and common throughways, it probably makes sense. It's reasonable to have those types of restrictions. So you would be able to include that presumably in your rules and regulations. However, for a homeowners association that has single-family homes with large yards, passing a rule to say that people aren't allowed to have dogs over 100 pounds may not be reasonable. There's an argument to be made there. So in that case, it wouldn't be necessarily a board rule that could come into play. But if you had that same restriction recorded in the covenants and restrictions of that community, it is presumed valid. And all you need is some type of reason. It doesn't have to be reasonable per se. It just can't be wholly arbitrary for that provision to apply. So be aware of that.
So I think, Adam, now's a good time. There's a bunch of questions that came in before the webinar even started, relating to rules and, can we prohibit guests from coming nowadays? Could you speak to that a little bit now, or?
Yes, absolutely. And so within the COVID-19 context, and this is somewhat of a general counsel issue as well, as everyone is aware, there's been a state of emergency that's been declared by Governor DeSantis. And with that declaration of emergency, a state of emergency, there are emergency association powers that now apply for community associations. So Gianna, if you asked that question to me a few months ago, can we prohibit people from coming on to the common elements? Can we prohibit short-term tenants from coming on if we don't have any restrictions otherwise? The answer would clearly be no. But under the current circumstances, one of the emergency power provisions in both homeowners associations and condominiums gives the board the right to close off portions of the community to not only guests and invitees, so that would be vendors and contractors, but tenants and owners as well. And that's a strange concept to think about, but if you look at it in the context of the emergency power statute, those were intended to address catastrophic hurricane damage. And if you think about it from that justification, what they were looking to achieve is allowing boards to prevent owners and tenants and guests coming back to the property when it was not safe yet, if there needed to be reconstruction. And the same principle can apply here for guests. The same principle can apply even for short-term renters. So even if you don't have those, anti-Airbnb provisions in your governing documents, you can still pass those temporary rules to prohibit people from coming into the community. In doing that, though, I would, and this just is a flat recommendation for every association, as you exercise these emergency powers, it is critically important to document the justifications for you doing so. Even if we are all conversing about it now and it is plain and simple, the challenges to these are likely going to be in the next year, maybe two. And if you're relying upon the CDC information that says you're not supposed to have any more than 10 people in any given place right now, and you have that website that you're checking, are you going to be able to find that same website in 2 years from the CDC? Maybe, maybe not. Which is why it's important to be able to document that in written resolutions that the board adopts. Reference the emergency powers, reference the executive order that declared a state of emergency, reference any other local health guidelines that have been promulgated by emergency management officials, so that you can have a paper trail for those decisions.
And that's a great point, Adam. There were a few questions about, maybe not necessarily a specific rule but whether something should be put in writing. And from a castle standpoint, absolutely, we are advising our communities to make sure they seek legal counsel, put anything in writing so that everything is crystal clear, and and make sure that they're applying things consistently too.
And that is a wonderful method to follow. And even though it sounds a little self-serving, I agree with you entirely that you should be checking with legal counsel. And all joking aside, if there is ever a time for a community to be relying upon expert legal counsel, this would be it. And we're just in uncharted territory, plain and simple. Okay, so unless you have other things, I will move down the list here. The rules governing individual lots and units. So this isn't as much of a problem or an issue for condominium associations, because almost all condominium associations have rulemaking authority with the boards over individual unit use. However, it is not a given that you will have, a board of directors will have rulemaking authority over individual lots in a homeowners association. It is very common for them not to have that rulemaking authority. So before boards get into drafting voluminous rules regarding what can and cannot be done on individual lots, make sure you verify that authority. Ambiguity of provisions. This is always something that is challenged if there's a covenant enforcement action. If it is not specific enough to instruct an owner to be able to comply with that provision, any ambiguity is going to be interpreted against the association in enforcing that covenant. So you need to be specific if you want to be able to enforce these things. And just from a general standpoint, I thought it would be important to mention fair housing discrimination issues in covenant enforcement. If your community is involved with, certainly with tenancy review and leasing review, this is an area that is fraught with peril for a FHA discrimination claim, increasingly so. And that's not to say that you cannot or should not do it. Many of our clients have adopted these types of restrictions, and we assist them in enforcing them as such. But you need to be aware of age and familial status discrimination claims, discrimination claims based upon race, ethnicity, sexual orientation, increasingly so. Certainly criminal history and disparate impact. So even if you have valid restrictions in your governing documents regarding criminal histories, and you want to prohibit somebody from renting in your community, if it is a relatively minor offense and you're prohibiting certain minority groups from moving in as tenants, there can be claims made, even if the restrictions are facially non-discriminatory, that they have a disparate impact on a certain group of the population in a way that it becomes discriminatory by enforcing them. So anytime you're dealing with leasing restrictions, you need to be careful when you're denying those applications. And then the last thing I'll point out is quid pro quo and hostile environment discrimination. And this is unfortunately something that has been brought into the realm of community associations based upon some guidelines that were disseminated by HUD. And in those new guidelines, so this was from a couple of years ago, it essentially said that associations have arguably a legal obligation that if they know of quid pro quo or hostile environment discrimination between two neighbors, so that the association isn't otherwise involved, but you have two neighbors that are discriminating against one another in a manner that makes one of them uncomfortable. So if it's racial slurs or displays to make someone feel that they are unsafe in their home, the association actually has an obligation to step in lest it be held liable for discrimination itself. We don't particularly agree with that approach, but it's something that you guys need to be aware of from an issue spotting standpoint. Okay, so procedural issues related to enforceability, these are fairly straightforward. You just want to make sure that those rules are properly adopted. So if you're going to be adopting rules that govern particularly individual units or lots, you're going to need a 14-day mailed notice. You may have specific governing document requirements that go beyond that statutory requirement of a 14-day mailed notice. So again, this is for condominiums and HOAs. If it's governing an individual unit or lot, say, you can't paint your house pink, or you can't have an overweight dog in your unit, those are things that are going to be 14 days at least mailed. The other rules and regulations that you may adopt for the common areas or common elements are going to be 48 hours posted notice. Make sure you have the approval threshold correct, total voting interest versus meeting attendance. That's a common slip up. The method of approval, whether it's by voting of the membership or by written execution of the membership. And there could be particular procedural requirements regarding recording. So for declarations, articles of incorporations, and bylaws, HOAs and condominiums are the same in that they all require amendments to those documents to be recorded in the public record. However, based upon oddity in the Homeowners Association Act, rules and regulations, which arguably could extend to architectural guidelines as well, are now looped into the definition of governing documents in that statute, and therefore need to be recorded prior to them being enforceable. So you need to be aware of those recording requirements and procedural issues.
So Adam, a question actually came in from Susan. She asks, do temporary policies imposed during this pandemic need to go through formal adoption as part of our documents in order to be enforced?
Yeah, so that's actually a really great question. And the answer would be maybe. Of course, that's the attorney answer. I would say the preferable approach would be to adopt a resolution, a board resolution. This isn't a rule and regulation that governs the community on a regular basis, but a resolution that assigns authority to officers of the association, so the president, vice president, to be able to take all reasonable steps based upon the advice of emergency management officials, which are local and state health officials at this point. And so from that standpoint, to give the board the authority to close down certain amenities, to prohibit tenants from coming in, giving that authority to be executed by an officer, I think is sufficient under the emergency power statute, rather than needing to reduce those restrictions to written rules and regulations that would otherwise need to be recorded. So that's actually a really great question. I mean, the bootstraps and suspenders, or the belt and suspenders approach, which is, you're trying to cover all bases. Of course, you can record it, but I don't think that's necessarily practical based on how quickly these circumstances are changing, which is why I like to build some flexibility into those resolutions. Okay, so other procedural issues related to enforceability, just make sure that you're following special enforcement provisions in your governing documents. And when I'm referring to these, I'm talking about alternative dispute resolution provisions. And I'm sure many of you on the call have heard of, Presuit mediation if you're an HOA, or arbitration if you're a condominium, and alternative dispute resolution options. However, increasingly so, we are seeing in governing documents private requirements for negotiation, for in-person negotiation that have strict timeline requirements, where if you send a demand letter, your first demand letter, and it is uncured within 30 days, you have that 30-day period to then request a meeting in person to negotiate. And then you'll have another 30-day period. And if you miss that 30-day period to then file a petition for mandatory arbitration or mediation, you end up waiving your claim entirely as an association. And so these are really poison pill provisions from a operational standpoint that communities can really get hung up on, because everybody thinks, okay, the standard enforcement procedures, I can just go to the statute. It says how I need to proceed with marching towards litigation. And that isn't always the case. So be careful of those special enforcement provisions in your governing documents. Okay, so identifying violations. The typical way of doing so, obviously, is to have CASEL, come through your community, to have drive-throughs, to have inspections, to visually identify violations that are occurring. In the current environment, is that safe? Are you dispatching managers or personnel into the communities to go through and have those inspections? And I guess that's even a question for you, Gianna. Is that something that you guys are continuing to conduct?
Absolutely, absolutely. So again, business as usual, but we are taking the necessary precautions that this outbreak is requiring. So social distancing, when we're doing inspections, we have masks on. We're 6 feet away from anybody that comes in contact with us. But definitely it's a great time. So it answers actually one of the questions. Our on-site managers are working. Now the amenities might be closed to the public, but the on-site managers are there and, are meeting with people on an as-needed basis by appointment. So the inspections are definitely going on. We would say in terms of violations, we're working with our boards to see, where do we need to be a little bit more lenient. If a homeowner is able to take care of something by themselves, great. But if it's something where it would require, an outside vendor, then, again, we're working with the board to create policies to see if, a little leniency is allowed during this time.
Yeah, and I think that's the right approach, because we're talking about it in a sterile environment here, but it's important to remember for everyone that this is a tragic human event that is impacting people in a myriad of ways, both health-wise, economically, mental health issues that are becoming an issue for the entire country, frankly. So I think that's appropriate. In terms of your community inspections, I would agree with you entirely. I think that's appropriate to do so long as you're adhering to social distancing guidelines. The only thing that gives me pause is interior inspections and issues within individual units. And I think those just need to be, frankly, decided on a case-by-case circumstance. If it's something that is a necessary issue that needs to be addressed, that would, otherwise give rise to unit access under the condominium statute, at least, then I think, there is still a overarching obligation of the association to protect the property, including other units, including the common elements, from additional damage. But if it's something that is more cosmetic in nature, or isn't as pressing from a damage mitigation standpoint, perhaps delaying some of those in-person interior unit interactions is going to be best as well. So the other issues that you have with covenant enforcement, which really isn't impacted by COVID-19, is reports by other owners and neighbors. We see this a lot when it comes up as behavioral violations versus physical property violations. With physical property violations, those are things that you can see with your own eyes. It's something that can be documented photographically. But if there are behavioral rules, such as loud parties or loud noises coming from neighboring units, or dogs barking, so on and so forth, there can be evidentiary issues when you get down the line. It doesn't prevent you from sending demand letters, certainly, but it's important for boards to realize that sending a demand letter based upon somebody saying, hey, I heard dogs barking last night, isn't likely going to be sufficient from an evidentiary standpoint for the association to overcome their burden of proof if they make it all the way to litigation. So I always like to tell our clients, if you're getting reports of behavioral rule violations, would be beneficial and prudent for the association to get a statement on record from those reporting individuals if they're willing. Obviously, that's not going to be practical in every scenario, but in some ways, and this applies for both directors and community managers, it also has a calming effect on overzealous and maybe even personal issues that can come up within communities. And we'd be naive to think that those don't come up as much as we take the defense of the associations. It's important to make sure that that boards and the associations have a proper check in how they're conducting their rules enforcement.
Yep. Well, and speaking of these behavioral rules, Adam, a lot of the questions for the COVID environment is related to, what do we do if people aren't wearing masks? And from a Castle standpoint, we've done our best to communicate and educate people about the rules, post signs as to, what you are requiring them to do. But if somebody is not wearing a mask, there are some things that we have deemed to be unreasonable for somebody to expect the association or even the management company to be able to police. So could you talk a little bit about that, Adam? Because a lot of questions did come up about specific rules like that.
Yeah, absolutely. And this is, of course, one of the first things that we're asked as attorneys for our clients. More and more, we are seeing people that are positively tested as having COVID-19 living within communities, and we can get to that in a little bit as well. But to the extent that the association is taking preventative measures to protect the health and safety of their residents, I think most of it will come down to closing amenities, which I think is a very important thing to do and is our recommendation, essentially unqualified for our clients to close their common amenities for the time being. But if people are violating those rules, one of the best ways of addressing those is to contact local health departments that are regulatory in nature and even authorities. Because if there are executive orders that are prohibiting people from being out in public if you've been positively diagnosed with COVID-19, it would be easier for the association to be able to have those authorities intervene rather than it becoming a combative issue between the resident and the association directly. The other issue that you have with enforcing those rules, this is not a time for overzealous enforcement as well. It needs to be monitored. You need to address those things on a case-by-case basis, but you need to resist the temptation as directors and CAMs to confront individuals in a hostile way. And the reason that I say that is many reasons, but one of the main reasons is I actually spoke with a virologist that is in almost daily contact with the Florida Department of Health, and their predictions for urban areas, the infection rate is anywhere from 30 to 40% by the end of the pandemic, meaning that 30 to 40% of people in densely populated urban areas will eventually contract this virus. That doesn't mean that they're all going to do it at the same time, but that's, flattening the curve, is extending it out. And so if you're overzealous in your enforcement and create a hostile exchange with owners that have been positively diagnosed on the front end, what practically is that going to achieve for your association? And the answer is the people that will become infected moving forward just simply aren't going to tell the association. And from our estimation, just as a kind of strategic standpoint, we think that the better approach is to invite people to inform the association in a way that is proposed as a cooperative and supportive role, that the association wants to know, and that if there are any issues that need to be accommodated to help facilitate social isolation and self-quarantine, to please reach out to the association to see if there's anything that we can assist you with. That doesn't necessarily mean that the association is going to be involved in those types of issues, but say if you're a high-rise condo, you might have a designated room for food delivery. So there isn't a personal exchange, or maybe they can use a service elevator instead of the main elevator if they're willing to do so. So it's a delicate balance. If you get to the point where it's just an egregious violation, you've said, people aren't allowed to be in the clubhouse at all, or you're not allowed to be in the gym, and there's a positive identified person in the gym and they're licking the handles on all the gym equipment. If it's something so egregious and clear, then you can certainly be able to rely upon, I would say, nuisance provisions. Even if you don't have specific written rules governing, no spreading of pandemic viruses within the community, which is, not going to be an enforceable rule, you can paint their behavior in a way that it is endangering the other residents, and perhaps seek emergency injunctive relief. So that would be the ultimate end to those things. But if you've already closed down the amenities, you've informed people, and they're still going to be coming out and violating those rules, unfortunately, fining and demand letters probably aren't going to do much more for people that are that obtuse or inconsiderate for their other neighbors. Okay, so moving on here. Oops, sorry there. Okay, so getting into the actual enforcement process. So first steps, obviously, are demand letters. Include those plain statement of facts at issue when you're sending those to the owners. Include the date of violations. Refer to the specific provision being violated. Be specific with the demands that you want to have cured. So you want to be, if somebody needs to repaint their home because they painted their home with a unapproved color, if they need to submit an ARB application, include that step in your demand. If their grass is dead, don't say, replace grass. Say replace grass with sod or reseed lawn. Try to get granular in the specific cure items that you want to have done. Include specific deadlines. Okay, costs of enforcement and pre-suit legal fees. This is an important slide for people to understand. The ability of the association to collect those costs of enforcement, including pre-suit attorney's fees, must be included in your governing documents to even be able to demand those. People assume, you send it to an attorney's office, you send that first demand letter, you can demand those, attorney's fees for that demand letter from the owner. And that's not the case unless you have those provisions in your governing documents. If you do not have those provisions in your governing documents and you still demand those amounts, then that demand itself can actually expose the association as well as management, as well as the attorney drafting the letter, to independent liability. So be sure that you're verifying that ability to collect those pre-suit costs. Okay, so moving on to probably the most talked about methods of covenant enforcement, fines for covenant violations. Associations may levy reasonable fines for failing to comply with any provision of the governing documents. This applies to both HOAs and condominium associations and is a statutory right regardless of what's included in your governing documents. The general maximum fine amount is $100 per violation per day, unless you are an HOA and have something else authorizing additional amounts in your governing documents. So for a condominium, you are capped at that $100 per day. But for HOAs, you can amend your governing documents to expand that amount. The same thing goes for continuing violations. So if you have a continuing violation, you can go up to an aggregate of $1,000. You have 10 days Somebody painted their house polka dot blue. That's obviously not on the color wheel. If it's there for 10 days, you can go up to $1,000. If you are a homeowners association, you can again amend your governing documents to expand that maximum amount. For condominium associations, you cannot place liens on units for fines. That is statutorily prohibited. There's no way around that. So you should not be placing those fines in a condominium association context on the general assessment ledger because they are not lienable costs. And if someone is paying their assessments on an ongoing basis and there's a fine that's on that ledger that shouldn't be, you can start that cascading waterfall effect of being perpetually behind based upon interest and late fees when perhaps it shouldn't be there in the first place. For homeowners associations, you can put a lien on lots for fines for $1,000 or more. So as soon as you get to that $1,000 threshold and above, if your documents allow for it, you're permitted to have a lien on the property, but we still want to see as legal counselors those provisions being specifically provided for in your declaration, particularly if you want to go through the foreclosure process. So we want to see, ideally, if you're wanting to use this from a lienable standpoint, we want to see increased fine amounts up to $5,000 to have specific lienable cost provisions and being able to collect those fining liens as any other assessment in the association.
Adam, if I could interrupt real quick, and
Yes.
somebody actually, I got some feedback that there's a tone when I speak together, so I'm going to mute you for a second.
Okay.
So there's a few questions that come in relation to fines, of course. Specific to COVID, people are asking whether we are deferring fines at this time. And also there's a question of owners being entitled to a hearing before a fine is imposed. So what are associations doing with these hearings? So again, from a Castle standpoint, I would say that it's association specific. Associations have spoken to their legal counsel as long as it's consistent. And again, depending on the violation, if it's something that you really want to push now, or if it's really something that's unreasonable for the owner to expect the owner to be able to do now, that is again association specific and specific to the situation. Hearings, again, depends on the violation. If that's really something that could be, or should be reasonably enforced right now. There are obviously associations that are taking advantage of the technology that's out there. Depending on the violation, if it's not seen as an emergency, these meetings, of course, need to still go through the proper, notice requirements. But there are different ways that associations are doing it using technology so that you're not meeting in person. So I'm going to mute myself and unmute Adam. And Adam, if you could put your legal input in there.
Absolutely. That's why I'm here, right? No, I would agree with that entirely. And I don't want to beat the dead horse so we can get through our materials. But the only thing that I would add to that, you absolutely need to have a committee hearing in order to impose fines and suspensions. So that is an unqualified statement. You won't hear me say, but there's an exception here. It's one of the few times, you can count them on one hand. You need to have a committee hearing to be able to enforce those fines. You cannot waive that opportunity. But I do think that it would be permissible to hold those via Zoom or some other type of webinar software, so long as the board approves those procedures at a board meeting, which could be done with the same resolution referencing emergency powers, and you ensure that the owners that are attending have the ability to converse, just like you would a telephonic or video chat board meeting. You have to have the ability to exchange conversation back and forth, information back and forth. But on the whole, I think postponing it, at least temporarily, for a month, maybe two, is okay. It's so long as you're being consistent. because the selective enforcement argument, that's what everybody is worried about. If you're treating everybody the same because there's a global pandemic and you don't want to have enforcement over 2 months, I think that's a defensible position that I'm willing to take should they be challenged. So real quickly, and did I get 2 of those? Oh, yes, postponing the fining. The other thing that I wanted to loop into that, and it's not entirely related because fining is not supposed to be a revenue generating vehicle that's geared towards compliance. It's not supposed to be something that you use to make money for the association. But people are also asking about whether or not they should be postponing collections and they should be delaying collections or waiving interest and late charges for 60 days. And I am okay with that. In fact, we're recommending, at least from a just a community standpoint, to do so for those first 60 days of quarantine. However, I have to advise our clients and everybody on the call that this is going to be a major long-term economic event for our nation. And if you recall back to the Great Recession of 2007 through 2009, the effects of that economic event did not end in 2009. As everybody on this call knows, there were significant financial impacts on community associations across the state for years to come. I still have clients that are dealing with some of those. So in that recession period, the highest number of weekly unemployment filings for the entire recession was 660,000 in 1 week. And over 2 weeks, we had over 10 million people file for unemployment benefits. And that's not showing any sign of slowing down. So even if we try to bounce back quickly, there are going to be significant economic issues for everyone moving forward. And for associations to be lenient in the beginning is appropriate, but you don't want to put yourself so far behind the 8 ball that you're digging yourselves out of a hole at the beginning of a very long economic battle for yourself. So just be aware of that. I'm going to try to skip through these as quickly as possible so that we can get to the Q&A as well. The suspension of use rights for covenant violations. You can obviously have those suspensions for common areas, for common elements, other association amenities, but it can only be for a reasonable time, and you can't prohibit access to lots or units. You also cannot prohibit the use of elevators and parking spaces if you're a condominium. The due process requirements, this is a very misunderstood area of this law. The first phase is appointing the enforcement committee. You must have an enforcement committee to levy fines or suspend use rights for covenant violations, period. That is a threshold requirement in the statute. That committee must be made up of people other than the directors and officers and employees of the association, or their spouse, parent, child, brother, or sister of those officers, directors, or employees. Appointment should be made at an open meeting, and the vote to establish the enforcement committee should include the names and be reflected in the meeting minutes for the board meeting. The second phase is, and this is important, so everybody pay attention, the board votes on levying fines and suspensions. Not the committee, the board is the one that initially proposes and levies a fine and suspension for a violation. This is done at a 48-hour board meeting, and they include the amount, they include the reasonable time. That is a board vote initially. Then, after that, it goes to the committee hearing process. That is when that 14-day notice of hearing is sent out to the owners, giving them an opportunity to be heard in front of the independent enforcement committee. The committee must actually meet, as indicated on the notice of hearing, and review the outstanding violation. If a quorum of the committee is not available to meet, You cannot impose the fine. It is not an appeals hearing. It is not a optional hearing if they elect to come to the hearing. In our opinion, it is something that needs to occur in our current context, and this applies to the board meeting in the previous step. We do think that you can take advantage of Zoom and similar services so long as you permit, particularly for the open board meetings, people to call in and make comments at the board meeting just as if they were attending in person at an open meeting. Then continuing on the committee hearing phase, if a quorum is met, the committee has to vote by a majority to either approve or reject the fine that's been proposed by the board. If you've ever seen the movie Gladiator, this is all the committee does. It's a thumbs up or a thumbs down. That is a statutorily limited role for the committee. There's no adjustment of the fines. There is no adjustment of the length of the suspension. It is simply a yes or no. After those fines are proposed, the committee should provide the results to the board of directors, and you must still mail a notice confirming the imposition of the fine or the suspension to the owners. And statutorily, at least, the fines are due within 5 days or upon 5 days after the actual hearing. Towing. This is a viable option for associations, but you have to have strict adherence to the Florida statute. So you have to have the signing requirements. It must be association property or common elements. You cannot tow off of individual lots. The association must own the property, or it must be common elements of a condominium for you to take advantage of that towing. Also be aware of municipalities and counties having stricter requirements. Okay, so for self-help, obviously there's a irrevocable statutory right of access for condominium associations to come into units to prevent damage, as we previously discussed. This is something where it should only be necessary in the current environment. If there is something that can be postponed, you should not be expecting your staff and your managers to be going into individual units unless they are properly protected and have the proper equipment and proper training to use that equipment. For self-help for homeowners associations, you can only enter on a lot to take care of those self-help provisions if you have it provided for in your governing documents. It is not the same as condominium associations. There is no statutory right of access. So you need to be sure of those provisions being present in your governing documents. I am more comfortable with outside self-help in the current circumstances than I am with interior help. So if you have landscaping self-help provisions, or there are landscape maintenance provisions, I'm okay with your lawn maintenance crews going in and making those necessary adjustments to an owner's lot. Mandatory pre-suit mediation. This is just a requirement for homeowners associations to go through before they get to the injunctive relief process. So the only thing I'll say about this, before you can file a lawsuit, you have to go through the pre-suit mediation process, unless there is a need for emergency injunctive relief. So if you're in a situation like we talked about before, where you have somebody licking the handles, the doorknobs in the clubhouse, that's been possibly identified, maybe you can skip the pre-suit mediation requirements. And then for condominiums, you go through the mandatory non-binding arbitration process. It's essentially litigation light. You go in front of an arbitrator. The arbitrator will render an opinion and say who wins and who does not. They can be appealed. That's where the non-binding part comes from in the title. But if a party does not appeal the decision within the time period for appeals, then it becomes enforceable and final, the arbitrator's decision. Okay, so we already went through a couple of these, the emergency powers for associations. The common area closures, again, I think that you should be closing these common areas as a matter of course. You should not be a leader as an association in your community of opening up common amenities, particularly if you have high-risk populations. And I'm thinking of HOPA communities, the active adult communities, where the residents are primarily 55 and over. I do not think that it is appropriate for communities to expect their management personnel to be conducting health inspections of their residents as they come into the clubhouses and amenities. I've had a client ask whether or not they can have their manager take temperatures and even do swabbing once the tests are available. The answer to that is no. Unless you have a registered nurse that also is a CAM, we'll deal with that question when it comes up. But it's not something that I think you need to be concerned about in terms of opening those activities up. Infected residents, so notifications, accommodations in quarantine, we talked about some of those already. I do not think there is an affirmative obligation to release information about infected individuals. I absolutely think you should not disclose the identity of anyone that the association knows is infected unless they have allowed you to do so in writing, clearly in writing, not an email, something signed that allows you to do that. And that's maybe something that you can look into in the future with the social tracing or contact tracing that everybody's been talking about, but only with clear consent being provided. And I think we address construction activities and collections as well. So I know we're running up against the time here for Q&A. So Gianna, what do we have in terms of Q&A that's come in?
All right, well, thank you, Adam. One of the things that I wanted to bring up is that, those of you that have participated in our previous webinars, Castle has talked about what we call our playbook, right? So having a plan in place that's specific to handling COVID issues. With what Adam talked about here in terms of what kind of communication you can put out there, what kind of steps are being taken by staff, please feel free to email info@castlegroup.com and we can share this information. As Adam said, we are not going to be determining when associations are ready to reopen, but what we want to do is be prepared for it. So it's going to be a phased process with different steps that you need to take carefully. And of course, it could be with a new normal at the end of the day. So that playbook is coming out soon. And again, please feel free. Our contact information is online. We did answer a lot of questions throughout. And I think a good question to end with, Adam, is COVID related. And again, appropriate to end. It says, if our association has instituted emergency powers resolution, should the board then move to rescind the resolution after the COVID situation is lifted, or will it be assumed that it is not active after COVID situation is gone? So I'm going to mute myself with that. And Adam, if you could answer that and close it for us. Thank you again to all of our boards and our committees for your dedication to your communities. And thanks for joining us today. I'm going to turn it over to Adam for the final answer.
Thanks, Gianna. And it's a good question, and it's a very easy one. You do not need to rescind it because as soon as the state of emergency expires, those emergency powers go away by law. So there is no other action that your board needs to take. So that's an easy one. I appreciate everybody attending. I know you have lots of things to do in this COVID environment, but we appreciate your time and we appreciate you being engaged community members. If you have any other questions and want some follow-up or even the slides that we've used today, please feel free to email Gianna or myself using the contact information on your screen. We really appreciate it. Thanks, everybody. Bye-bye.